Hi everyone, this is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. I want to formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their green card and status in the United States. I'm also here every night at 9 p.m. to take your immigration questions. So feel free to put anything that's immigration related in the comments and I will answer. So tonight I am going to be talking about the different ways that you can obtain permanent residence even if you are without status in the United States. So I'm going to talk about the various different ways. So it's going to be a broad overview, but this is what really guides the conversation and allows me to give you information that's meaningful that you want to hear. Is your questions. Your questions provide, allow me to give you the information that you care about. So at any point while I'm talking, please feel free to put your questions in the comments and I will answer. Hi there, Wilhelmina Bobby. It's nice to see you. Thanks for saying hello, and go ahead and put your questions in the comments. So applying for permanent residence, even while in the United States without status, can it be done? The answer is yes. Now, does everyone who qualifies for permanent residence, can everybody who qualifies for permanent residence also apply for their permanent residence while being in the United States, especially if you're out of status? And the answer is no, but I'm going to tell you the ways that it can be done. So only specific individuals qualify to stay in the United States and apply. And so I'm going to clarify that. Because one of the most common questions I get is, I have a U.S. citizen on, I came here on my visitor's visa, I overstayed, can my aunt apply for me? And the answer in this case would be unfortunately not, because not every relative can apply for your permanent residence. And also, even if you qualify for permanent residence, it doesn't necessarily mean that you can stay. But in the case that you are in the United States and you're without status, can you adjust status? And the answer is, are you the immediate relative of a U.S. citizen? If you're the immediate relative of a U.S. citizen, that means you're the spouse of a U.S. citizen, the parent of a U.S. citizen who's 21 and up. Hi there, Yatin. Or a son or daughter of a U.S. citizen who is under 21 and you came in with a visa even though it expired, then this could be a possible path for you, is to stay in the United States, get a work permit, get an SSN, and be able to adjust status in the United States. I filed for my husband when I have canceled, but I have canceled. Do USCIS send letters to show that they have canceled? Yes. So once you have withdrawn your petition for your husband, they will send you a petition. They will send you a letter confirming, acknowledging the withdrawal and confirming whether they withdrew the application. Hi there. So why are they changing processing times? It's not necessarily that they're changing the processing times. There's a specific strategy. It's more related to the backlog, and so processing times are changing just based on the volume of the applications and then how backlogged they are. So also processing times really depend on, for example, if you're waiting for an immigrant visa number, if the applications outnumber the immigrant visa numbers that are available, then you're going to have a wait list that's going to keep growing. And right now you do have wait lists that are years long. And it also yet depends on the types of processing times you're referring to. How long does it take for the USCIS to send you the letter? So it just depends. It could be a few weeks. It depends. And no, your money is not refunded because when you submitted it, once they accept the application and it does go through some processing, they will not refund that money. So now it's saying 23 months to 29 months. So yes, it could be related to the backlog, Yatin. Unfortunately, that does happen. So if, for example, if the office is overburdened, or they have many more applications, then you're going to see an increase in the processing times. So keep your questions coming, because that's why I'm here. I'm also talking about who can apply for permanent residence while being in the U.S., while even being without status. Now, what I want everyone to understand is that if you are here and if you qualify for permanent residence and you can continue to maintain your legal status in the United States for the duration of the green card process, then that is a way to adjust status. So for example, say you came here on an H-1B and you are able to have your H-1B for a certain number, say 4 years. So say you're able to have your H-1B for 4 years, and say the permanent residence process takes 2 years. Then in a case like that, you could be confident enough to know that you would be able to do adjustment of status and be able to maintain your legal status, as long as the thank you, Princess Style, as long as the status doesn't expire or you don't lose the status, then you'll be able to complete the green card process while staying in the US. Now, if you have fallen out of status, so for example, you came on a visitor's visa, usually with visitors visas, you can only stay here for about 6 months, or within the time given by the officer. And in a case like that, it's very unlikely that you'll be able to maintain status, legal status, just because the green card process is years long, where your visitor's visa is only it's only going to last a few months before you fall out of status. In a case like that, you have to be the immediate relative of a U.S. citizen to be able to qualify for adjustment of status. So how can I check if my file at Service Center, because it was in California, now it's in Texas, how do you know all that? So what you can do is you can call to see where your case is right now. So keep your questions coming. I am here to answer your immigration related questions. So put those questions in the comments and I will answer your questions. I am talking about ways that you can be in the United States and still adjust status, even if you adjust status or apply for permanent residence, even if you're already out of status. So if you're the immediate relative of a U.S. citizen, that is one way. Hi there, Sexy Annie. It's nice to see you. Keep in mind that you have to enter, if you're an immediate relative of a U.S. citizen and you didn't come in with inspection, that means you didn't come in with a visa or any kind of permission, then that is going to be, so Yatin, if you called, I wouldn't be able to help you here about your specific case. I'm giving general information. And so if you're concerned about your particular situation and your case, you can always call the office and schedule a consultation and we can get into detail about your particular situation. You can call 561-405-4889. And then the scheduling coordinator is available up until 11 p.m. to answer your call and schedule the consultation, so I can get in more detail about your situation. So now, if you're an immediate relative of a U.S. citizen and you didn't come in with inspection, that means you didn't come in with a visa or any type of permission, then you're going to go through another process that I'm going to talk about. And unfortunately, you wouldn't be able to qualify for adjustment of status unless you're applying for VAWA, for example. So as you can see, there are the rules and the exceptions to the rules and then exceptions to the exceptions. That is why immigration law is something that you should always make sure you check on, make sure you qualify for it, and really look into your options before starting the process. Now, as the immediate relative of a U.S. citizen, you have to be the spouse of a U.S. citizen, the parent of a U.S. citizen who is 21 and up, or the son or daughter of a U.S. citizen who is under 21 and unmarried. If you don't fall within that category and you're out of status, even if you came in with a visa, you're going to have to go through the waiver process to be able to get your permanent residence. And when I say waiver process, it doesn't allow you, it allows you to stay in the United States and wait for the waiver to be decided. And if your waiver is granted, this waiver I'm talking about is basically forgiveness for the overstay. And if it is granted, you would be able to go to the embassy go to the interview. So schedule, make your travel plans to attend the interview in your home country, and not be in fear of being penalized or being denied because of the overstay. That's the main purpose of this type of waiver. So, in the case that you don't fall within the category of an immediate relative of a U.S. citizen who came in and overstayed, then you will likely have to pursue this waiver process. I'm going to talk about it in a little bit, but I still want to touch on the adjustment of status process. So if you're out of status, you've determined that you still do qualify for adjustment of status, though. What does this process look like? So the process is you submit the application, because the great thing about adjustment of status is you get to stay in the United States. At the same time you're applying for permanent residence, you can apply for a work permit that will be granted while you wait for a final decision on your green card application. You'll get an SSN also during the process, and a travel document if you choose to apply for those, of course. Now, once you submit the applications, you usually are scheduled for a biometrics appointment. That's a fingerprinting appointment for the background check. And then after that, about 6 to 8 months, a work permit, your SSN comes. And then you'll be scheduled for your final interview. Right now, you're looking at about an 18-month total process. 18 months, it could be as long as 24 months. Now, at that point, you would be able to once you attend the interview and you qualify in every way, at that point, you would be able to get permanent residence. Now, in the case that, even in cases where you're not just the immediate relative of a U.S. citizen, there are some cases where you can adjust status. You can apply for permanent residence while being in the U.S. And that's if you are a VAWA applicant. Hi there, Erin Love. It's nice to see you. Thanks for saying hi. Go ahead and drop your question. Now, if you are a VAWA applicant, you can also apply. Now, this is the good news. You could apply as the spouse of a U.S. citizen or resident. So now it is not just narrowed to U.S. citizens. If you are being mistreated, abused, or subjected to extreme cruelty by a U.S. citizen or resident spouse, if you're under 25, a U.S. citizen or resident parent, or a son or a citizen son or daughter 21 and up, they're subjecting you to abuse, mistreatment, then you could apply for status, a work permit, and your permanent residence while staying in the U.S., even if you came into the country without permission. So that is the exception to the exception that I was talking about. Can I sponsor my fiance without the U.S.? I met her through social media. So if you are a U.S. citizen, the only individuals that can sponsor their fiance are U.S. citizens, and you have to meet specific criteria. So the first is you have to show that you've met your fiance within the most recent 2 years, the last 2 years before you submitted this application. So that is the first thing. And if you can't show that you saw them in person, you have to show that there's some kind of exceptional hardship, or that there is a tradition or some kind of religious custom in your family, that family, culture, religion, that imposes rules that say you can't meet each other, you can't meet your fiance until marriage. So what you can do is schedule a consultation, and we can definitely talk about the requirements. So you definitely have to meet your fiance, unless an exception applies, of course. But you'd have to meet them before you sponsor them. Now, with the fiance visa, once you do sponsor them, you would submit a petition first. And then once the petition is approved, with the petition, you have to show that it's a bona fide engagement, that you do intend to get married. And then you also have to show that you've met in person, as I said before. Once the petition is approved, it gets sent to the National Visa Center, and they request additional information, and then it's sent to the embassy in the country of your fiance for an interview. And she would have to do a medical, submit an affidavit of support. That affidavit of support is completed by you. That says that you will support your fiance while they're in the U.S. And then if approved, they would have 90 days. So it's a 90-day visa to get to the U.S., get married, and then do adjustment of status. So WASI 11, what if my fiance has children? Your fiance can take their children as long as they are under 21 and unmarried. Those children can go along as well. And so they would take on the derivative K visa and come along as well. So I might as well get married to bring her faster. So I wouldn't be able to confirm that unless I speak with you in a consultation. What I can say generally is that the K visa, as well as the marriage-based immigrant visa, are both taking more than a year. And so most individuals think that the K visa is just a few months, and it's taking longer than that right now. And so it may be more convenient to see your fiance get married, and that way when she does attend the interview, she can come straight to the U.S. and become a permanent resident. Whereas with the fiance visa, it only allows your fiance to come here for 90 days, and then you have to get married and do an adjustment of status within that time as well, to avoid her falling out of status, or your fiance from falling out of status. So it really depends on what works for you. That's what I like to say. The fiance visa versus the immigrant visa, it's more of a personal evaluation, and so I would really have to hear your particular facts to determine which one would work better. So how much is a K1? So you would have to pay that initial petition fee, so the $535 to start, and then you'd have to pay additional fees later on to the National Visa Center in order to process the application. What about bringing my brother? He is over 21. So as long as you're over 21, you're a U.S. citizen, Erilove, you would be able to sponsor your brother. But keep in mind that your brother is this process is taking at least 14 years, and it really depends on the country you're in. For example, in Mexico, it's taking up to 20 years. And so it's a very long process. It probably may still be worth pursuing if that's the only way your brother is going to qualify. He and you would just have to be very invested, very patient, to wait out the process. So it's not a quick or easy solution, but with some perseverance, it could all work out. So keep those questions coming, because I'm here to answer your questions. I'm talking about ways to adjust status in the United States, even if you're out of status. So I talked about being the immediate relative of a U.S. citizen. So Erilove, yep, it's taking 14 years at minimum. 14 years at minimum. Of some countries, it depends on where you are. So now, if you're the immediate relative of a U.S. citizen, you came into the country with a visa, even if it expired, even if you're now out of status, you can likely apply for adjustment of status. assuming that you qualify in every other way, that there are no other disqualifying factors. However, keep in mind that in the case you're being mistreated by a U.S. citizen or legal permanent resident spouse, if you're under 25, a U.S. citizen or legal permanent resident parent, or a U.S. citizen son or daughter who's 21 and up, then you could apply for your own permanent residence, stay in the United States based on that mistreatment. Now, that mistreatment doesn't have to involve physical violence to qualify. This could include emotional, verbal abuse, financial abuse even. And so if you're going through something similar, my rule of thumb is if you are in a situation where, and so every love, what if there is political unrest in that country that could possibly fall under the exceptional hardship? So it would really require a consultation to determine whether the political unrest in the country rises to the level of an exceptional hardship. You can call 561-405-4889 to schedule a consultation. Get on my calendar. Let's talk about your particular situation, the conditions that your fiance is living under, to determine whether you could qualify for an exception to the rule that you must meet in person. Now, with VAWA, my rule of thumb is if you're being mistreated, if you're not being treated right, you feel like you are getting the raw end of the stick, then you should definitely look at whether you qualify for this. So I have trucking company. I want to sponsor truckers from overseas also. So that could be a possibility through the EB3 employment visa. So you do have to go through the labor certification process, of course, and that is usually the more complex aspect, but it is possible. Now, Love, when it comes on to employment-based visas, they can be on the more complex side, just because my advice to you is going to be dependent on what you need. What do you need? Whether this the qualifications of the employee will work in this particular situation. And so you should definitely schedule a consultation. It sounds like you have multiple immigration questions that require a more detailed consultation. So if you are going through mistreatment and you would like to decide, and you would like your papers, you want a work permit, you want your 10-year green card, you want a social security number, you want to move forward with your life, you want independence, then this could be a way for you. This is actually here. It is a form of relief for you, and it's broader because it is that one exception to the rule that allows Love, you're welcome. It allows individuals who are more leeway to be able to seek relief and status in the United States. And so you should definitely schedule a consultation to talk about your options. Now, with this process, the next thing there are two major questions I get. And the one is, so as for the business visa, can you employ family? Yes, it is possible if you do it through the business, of course, and you have to meet all the other requirements in order to do that. So in order to sponsor a family member, you do still have to meet those requirements. So keep those questions coming. So far, these have all been great questions. Now, if you are, there are two major questions I get with the VAWA. Is one, will my relative get into trouble if I am submitting this application? And the answer is no. The application is only there for the immigration officer to evaluate whether you qualify based on the mistreatment. They don't report it to the police or send the police to go and arrest the family member. Or they don't start a whole investigation, separate investigation, other than to review the application. And so it's Love scholarship visa for bright students. So not necessarily, there are no scholarship visas. However, there are schools that offer scholarships to for international students. And so you'd have to look at the schools and determine whether there's that possibility there. So the other question I get is, will my relative be notified? Does my relative have to sign any documents? Do I have to still get their permission? Will the officers call them to verify? And the answer is no. They will not. So how hard is it to switch from the B1 to F1? So it is not necessarily, it is a possibility to do that, but it really depends on your timing and what's going on with your, when are you applying for the student visa? Are you at the tail end of the application process, or are you just now thinking about transferring from B1 to F1? So you're definitely going to have to schedule a consultation to talk more, but it is a possibility to switch from B1 to F1, but it depends on the timing of your application. And usually what you'd have to do is you'd have to apply for a B1 extension and change your status to F1. And then once you've gotten accepted, then everything goes well and this approved, you get the status approval, then you should be good to go. But as to how hard it will be really depends on what your particular circumstances are. So so keep in mind, this VAWA process is extremely confidential. So it is not something that they're going to call the relative about. If you don't tell anybody that this process is pending, they will never know. Nobody will ever know that this is the way that you applied for it. So if this is something that's familiar to you, you should definitely schedule a consultation. And then let's talk more about your situation to determine whether you qualify. Sexy Annie 35, thanks for sharing the live. I appreciate it. So now I talked about VAWA. I talked about being the immediate relative of a U.S. citizen. Now I want to talk about the alternative. What if you don't qualify for any of those, and at this point you want your permanent residence? Now, the bad news is you may not be able to adjust status. I never like to say on here, because this is not personal legal advice, it's general information. However, if you don't fall within those categories, you definitely have a narrow set of options left. And one of those is to apply for a waiver. Now, the waiver is basically forgiveness for the overstay. And it doesn't allow you to stay in the United States and apply for your permanent residence. But what it will do is it allows you to go to once you get the forgiveness through the waiver, and you can wait in the U.S. for the decision on the waiver. You can wait until your interview is scheduled. Then you purchase your ticket. You go to the interview, right? So you guess a week or so before the interview, you can fly down, fly to your country, go to attend the interview, and the waiver, if the waiver is granted and you have no other disqualifying issues in your background, you would not be denied based on the overstay, and would likely get an approval and come right back. And when you land back in the U.S. about 2 to 3 weeks after the interview, you would become a permanent resident. For some individuals, if you don't qualify for adjustment of status and you have an overstay, unlawful presence, meaning you overstayed over 180 days in the United States, so more than 6 months, this is the only option for some individuals. Now, I am finishing up tonight because I'm hopping on over to Instagram for a pre-scheduled live. If you don't want to end the conversation, you still have questions, you are welcome to join me on Instagram right now. You can go to the link in my bio, click on Instagram. It will take you to my page where you can follow me, and then wait for me to hop on in a minute. Now, I want to let you know, if you can't join me on Instagram, you can always come back and meet me here at 9 p.m. every night. I'm here every night with very few exceptions to be able to answer your immigration questions. So go ahead and join me now. Now, if you know that you want a personal consultation where you can get legal advice, where you can know your options, you can know how to approach your situation, you can know whether you're on the right path, and most importantly, you can avoid mistakes, then definitely go and call the number 561-405-4889 to schedule a consultation with a scheduling coordinator who is available up until 11 p.m. Eastern Time to take your call and schedule the consultation. Scheduling coordinators who schedule the consultations are available Monday to Friday, 9:30 a.m. to 11 p.m. and Saturday and Sunday, noon to 5 p.m. So feel free to make that call. Otherwise, I'm hopping on over to Instagram right now. I'll see you in a minute. Thanks so much for your questions. Have a good night if I don't get to see you again, and a good weekend if I don't see you again on the weekend. But keep in mind, I will be here at 9 p.m. tomorrow and the night after and the night after. Have a good one, guys. Bye.